Everybody, welcome to the TPS Report HR podcast hosted by the Bobs. Bob 1, Arta Wildeboer, that's me, and Bob 2, Ryan Ellis. We're both attorneys here in California who are doing a HR podcast to talk about a attorney's perspective on what goes on at your companies and how to solve some of the more common problems that HR professionals deal with. Ryan, I want to go ahead and say hello to you. We want to say hello to our huge fan base that we have over here.
Yes, hello to our huge fan base here. Excited to be here for episode 2. Got some good stuff to talk about today and hopefully help everybody get through today.
Yeah, so one of the things that we talked about in the first episode was how, I think we did at least, but a lot of companies end up dumping tons and tons of problem area work and things that nobody wants to do at the office on HR. So HR a lot of times gets called the party planning department because, you know, they're always planning a pizza party for this and that, or get made fun of for not being the most serious department that doesn't have a sales job or something that can really be, I would say, counted or what's the word I'm looking for? But
yeah, that attributes value or worth to the business directly.
Yes, it's something that it's hard to measure the contribution of HR. So a lot of times different departments, managers, they want to dump jobs that they are not comfortable doing or feel like are below them on the HR department. And that has kind of created a very unsure environment for a lot of HR people where they don't know exactly what they're supposed to be doing. So today, what I wanted to do partly is talk to Ryan about what are the essential functions of HR and how HR should be set up at a company and what its role should be. So Ryan, I want to go ahead and maybe you can just give me your idea on what HR department in a company should look like and what it should be doing.
Yeah, of course. I mean, it's a funny topic or funny intro that you brought into the very interesting and rabbit hole like topic, because when you think about it, HR does a lot more than just human resources, right? I mean, human resources itself is a broad phrase and necessitates a very lengthy discussion as to all of its facets and also classifications, right? So some clients of ours will include like onboarding is definitely a human resources task, but recruiting is HR. To me, that's a separate department. Some people like to have it in HR or classified as HR, even though it's more of a separate thing because a lot of that gets outsourced. But to me, human resources starts with the employees, right? So human resources is entrusted and responsible for making sure the employees have here in California, especially an employee handbook, policies and procedures, and that the employees know what those are. Whether or not to discipline those employees because they're not following policies and procedures, that's a little bit of a more gray area. Then you have accounting, you have checking timesheets. Is that part of HR? Is it not? I think that would be more of an accounting role. Some people classify payroll departments as human resources. It benefits people. You have a leave of absence people, and you have compliance officers and compliance employees to make sure that the company and its employees are compliant with whatever rules and regulations and laws might apply. This, I guess, is a really bad segue to getting into the thought that HR being a pizza planning department or, you know, head of pizza ordering technology department really gets assigned, their human resources itself really gets assigned a lot of things that don't necessarily apply to it, but yet for some reason the HR professionals do not want to give up the tasks and will do them despite them being part of their job. And I'll take the lowest hanging fruit here, which is legal. For some reason, every single client I've ever dealt with, potential and actual, have always had.
You mean companies, right?
Yes, client companies. Every single one that I've dealt with, either in litigation or in consulting for HR, on either side, has always had at least one semi-major to major facet of its business that should be handled by a licensed attorney, handled by unlicensed, but really licensed HR professionals who are not licensed in law. And what that does is it puts the company at more risk. But again, a weird feeling of the HR, what is it? The character from Lord of the Rings where they wanted to keep it close and not Yes, to not let go of it, like, oh, am I precious for some reason?
Well, I think you touched on a couple important points there, that HR is doing jobs they're not supposed to be doing, as well as jobs that are getting dumped on them in terms of like party planning and things like that. But yeah, the more important thing is there's a lot of crossover between HR and these other departments. Like you said, payroll could be an accounting thing, and probably should have a lot of cooperation between the accounting department and HR to figure out payroll issues and to audit payroll, and also compliance, what you were talking about, policies and procedures, and being able to comply with California law or whatever state law you're in, becomes very much muddled because of the legal implications for a lot of this stuff. And it seems to me that maybe HR can be looked at as a jumping off point for these areas, to be able to kind of take these as an intake department for some of these things, and then go ahead and report to attorneys. So could you give kind of an example of something that an employee would come to HR for, that should be handled by general counsel or outside counsel?
Yeah, and this is going to vary depending on how much HR tasks bleed into other business functions. So, for example, if you have a 50-person company, the HR person may have a few hats to wear, one being accounting, one being human resources, and one being like just general admin. And a lot of times that general admin is to one of the partners or CEOs of the business, which means that they're handling a lot of weird tasks that the CEO or the partner doesn't want to handle. And one example of that would be signing contracts or drafting and reviewing contracts. A recent example that we dealt with was the admin person was tasked with signing a payroll company contract and didn't necessarily know what that payroll contract entailed, but also what the payroll company needed from the client in order for it to work. California, again, is a bunch of expletive words come to mind when you think of how it runs its laws. Very employee friendly, which is good, but it makes management of business very difficult. And going back to the example, one very large payroll provider requires its clients, so the companies, to delineate its own payroll classifications. And in this particular example, the administrative person did not know what payroll classifications or exemptions or classifications of employees' job titles or salary versus hourly, independent contractor, otherwise. And it just, by not doing it properly as an HR person or admin in that situation, and not consulting at least with legal or anybody else, that became a humongous issue to unwind through the legal system. That is one example. A much easier example is if you have a vendor coming in to sell like soda and snacks. Sometimes those people require contracts, and an admin person or an HR person might just say, yeah, that's fine. It was handed to me. I'll fix it, because the person who handed in the contract didn't want to hand it up top to a higher level C-suite individual. HR reviewed it and signed it, which led to issues with placement and potential sublease / assignment issues of their office. So a lot of weird things come up in HR that should just be handed off. Contracts and business level decisions specifically should not be made by HR solely.
I think there's like a weird dichotomy going on with HR, because a lot of times people are getting stuff dumped on them in HR departments that they're not supposed to handle, like you just mentioned. But also what tends to happen is that the HR department kind of feels afraid of going to their superiors, because they don't want to seem like they're not able to handle the different parts of the job that have been handed off to them that aren't necessarily their responsibility. And can you talk a little bit about how that can get companies into trouble?
Yeah, and that's kind of like the Gollum syndrome. I think we're going to dub it now, because they get a task that they're not necessarily responsible for, yet they're doing it. Trying to think of a good example, because they're all very long. I think one of the ways we'll just kind of box us into how to handle those situations, and how to handle that situation is to literally speak with somebody who has power to assist, whether that be a coworker in your department. If it's something that you shouldn't be doing, then you should be talking to somebody higher up, or a VP, a director, or somebody else. Because at the end of the day, if you keep your mouth shut about it, my personal advice, if you keep your mouth shut about these things that you're not responsible for, or you shouldn't be responsible for, and you do them anyway, not only are you going to be required to do them in the future, putting more work on your plate that you shouldn't be doing or can't be doing, or two is now you have an issue with you might be doing it incorrectly. And again, being a lawyer for almost 15 years now, I've seen a lot of situations that people just make flippant decisions, thinking that it's right, but not knowing the actual law. So I think setting standards, setting guidelines, setting boundaries is very important in all aspects of life, specifically when you as a person or a department are not qualified or prepared to handle those things.
So yeah,
have you had an example recently of when somebody in HR was handling things they shouldn't be?
well, one thing that I heard an HR person say was a lot of times they're not considered as HR being like a real job because of the mishmash of things that they have to do, and not having these defined roles, and people not really listening to HR departments because they see them as ancillary to the core of the business, where it seems like HR is kind of the core of the business when it comes to administering employees and dealing with internal problems that could lead to lawsuits. And one thing that this person said is kind of a quote is, HR isn't a real job until you want me to fix your mistake that you made, that you were warned about on the front end by HR. And I think that's a huge problem that we see, is that people don't give HR the respect that it deserves when they're telling them or warning them about potential pitfalls, and then run to HR and tell them they have to solve all their problems when it's something that the manager or employee thinks is out of their competency area.
That's actually a very good point, is that it highlights the fact that, and I think we spoke about this last time, that HR seems to be permanently undervalued and undersupported, while at the same time
Overburdened.
Well, overburdened, but I don't know what the right word is here, but HR makes a decision or tells an employee what to do. Employees rarely, if ever, listen to that instruction, and it causes the company harm or more work for somebody, whether it's HR or otherwise. Yet, when that happens, the company doesn't really do anything to enforce those policies. And I think, especially in California, I think that happens because there's a lot of issues with employees actually doing their jobs, whether it's, and I'm not making a political stance here or a generational stance here, but whether people think that they shouldn't have to do their job or they're entitled to do what they want at their work, whether you're young or old, it doesn't matter, political, race, sex, national origin, gender, any of that, all that aside, some people don't want to do their job even though they're being paid for it. They think they're entitled to that work. Other people get mad at the people who think they're entitled to it, and it causes rifts. So sometimes employers don't want to make a rash decision or policy decision towards an employee who might just quit or leave, and then sue them, at worst case, for making them do all these things. And I've seen that happen. And so the employer in these situations would rather have the body at work to do the work or potentially do the work, even though they're not performing, instead of just simply disciplining. But then when you get down the road, and maybe I'm just too off on a tangent here, but then down the road, when the company says, hey, HR, we want to fire this person for whatever their cause they believe to be, there's nothing in the file to support such a termination on the basis that they're, alleging, which in these situations, a lot of it, especially through our office, we see that, well, we fired them because they weren't performing, but let's say it's a minority person with a different religious background that has a disability, some protected class aspect, either under California or federal law. And they're like, well, we fired them because they weren't performing. And then my first question is, well, give me the file. And then after reviewing the file, you see there's no performance improvement plan. There's no warnings. There's no discipline. There's nothing. Then the person who gets terminated, above and beyond advice that we give not to, comes and sues the company. And the company's like, well, why did you make me do this? And I say, what are you talking about? Like, this clearly looks like you fired them for insert protected class reason here. So to wrap that up in a bow would be that employers are afraid to back HR because they're worried about themselves in certain circumstances, and then they're worried about their employees on other circumstances, which would go against HR. And then at the end of the day, everybody loses because the employee has to sue, the employer has to spend a bunch of money to defend it, and the company gets a bad rep for not just doing the right thing.
And we're coming up on our first break at 15 minutes, but one last thing that I wanted to touch on that you briefly mentioned and a problem I see a lot of times with companies is that they treat problems that happen as a one-time event. And like you were saying, they don't document, they don't do anything in terms of a performance improvement plan or anything that shows that the company has been looking at this long term. And what happens is they solve this one problem by the skin of their teeth, and then they don't make lasting policy changes that will stop this from happening again. And that really comes back to bite them in the ass. So
Every time.
yeah, well, we were touching on the handbook for a brief moment, and we'll go into our next episode into handbooks in more detail. But these things are kind of living, breathing documents that need to be changed and updated as work and the work environment and situations at work and change. The company grows or it gets smaller. All these policies and procedures have to reflect these changes in the company. And people, I think companies will treat their handbook as a static document, or like the Constitution or something like that, that it can't be changed, or the Bible, that we have our handbook that we downloaded from ADP, and this is gospel. And that's not how it should be. If you're seeing certain things happen, you have to address them in the handbook. And anyway, so we're coming up on our first break here for our first segment, and we're going to get into a little bit more of what roles HR has been given that they shouldn't be doing, and what should be handled by management in the company. Okay, so we're back, segment 2 on the TPS report and HR podcast with the Bobs, Arta and Ryan. We were talking about earlier today, or early in the podcast, I should say, we're talking about things that HR has been tasked with that aren't necessarily HR jobs. And we want to go into that a little bit more in depth and give you kind of a top 10 list without 10 things in it, or I don't even know how many things are going to be in it, but
a top X number of things list, however many we can remember.
Yes, exactly. Yeah. So the issue, as we were talking about, is HR has to do a lot of things that HR shouldn't be doing. I personally, as a plaintiff's attorney, look at HR as strictly an administrative function within the company. They're there to help the company come up with policies and procedures that should be done in concert with general counsel. And also a big thing that we have is disciplinary issues for HR. And so the first thing that I want to talk about, and Ryan, I'm just going to introduce, and you could talk about it, that HR should not be a referee between employees or handle disciplinary issues. I think that should be the manager's role. And so I just want you to talk about what HR's role should be in disciplinary issues, and how this kind of goes wrong and what the effects are.
Yeah, and that's a very rabbit hole-ish topic. I guess I'll use that term a lot today. I find, because in the litigation perspective, from plaintiffs, or when I represent companies in litigation, a lot of times I get the response from a plaintiff's attorney like yourself, hey, why didn't HR step in? I get that question a lot. And then a lot of times my response is, well, this person did X, whatever that may be, that was in violation of whatever policy it was, and it was handled by the manager. And that is valid, depending on what happened, if it was a write-up or whatever. Managers should be empowered to provide write-ups or notes to file for employees that they manage, especially if they're witnesses or handled the quote-unquote investigation of that issue to the extent necessary. Like an easy example is the person was late to work in a branch of a facility, and the manager realized they weren't on the assembly line that morning. They came in 30 minutes late. The manager should have all the power in the world to give that person notice, write them up, and put a note to the file, to send it to HR, put it in their file. Literally just said, put in person's file. HR has no interaction. And if that happens over and over, we get to a point where we need to involve HR, in my opinion, because the manager can't terminate that employee. Although they might be able to, it's not something they should just do, by themselves or without consultation of upper management or HR. And a lot of times the HR departments aren't allowed to fire, even though they have the authority. They need to take into account the upper management or departmental viewpoints on it. So I do agree that the managers, man, this lingering cough is killing me. I'm sorry, everybody. But the managers do have the power and should have the power to enforce the policies to a certain extent. And at a certain extent, 3 or 4 times, which again, the policy may state, it gets forwarded on to HR or higher up, or even like a divisional manager instead of a departmental manager, something like that, because eventually the person needs to be furthered on to discipline or furthered on to whoever else that can make that advanced discipline. Your thoughts?
Well, the way I look at it is very similar to you, that these decisions, say disciplinary issues to terminate somebody, those should be made in concert with general counsel and the manager and HR. I think the roles have to be defined very, very well between those 3 groups on making a termination decision. I think the managers basically need to manage people. That's their job. They're the ones who are in the best position to know whether or not their employee is meeting the standard that the company has set for them. And then if there is an issue, they need to go then alert HR that they're thinking about terminating somebody, go over the policies and procedures. If anything is stepping over the line from what HR's competency is into legal issues, say because the person is pregnant, or there have been medical issues that they've had, and it might trigger some sort of discrimination issues, then they need to go straight to general counsel and discuss the issues with them. And I think the best way to handle it is having the manager doing the actual terminating, with HR sitting there next to them, providing support in terms of documentation, paperwork, and making sure any internal company policies for these issues of termination are handled. But the manager is the one that needs to do it. And I think one of the problems is it becomes very difficult as a manager to have to discipline people that you work with every day, because of personal relationships, and also when you want to give somebody a warning for, say, being late, people take these things very personally. So it becomes very difficult for managers emotionally to take on this job of disciplining people. And I think that's a big reason they try to dump things off onto HR.
But so 2 points here to make, and that's a very good segue to what I wanted to make as a point here, which is part of being a manager is managing. And you're not managing yourself, you're managing other people. And that's, I think, why a major majority of people in a management capacity who manage other individuals have difficulty, because they don't want to do their job of managing. And that's like, hey, pulling somebody aside and talking to them as a person, disciplining somebody, because again, you might be friends with them. You and I might have worked on the assembly line together. You might get promoted to, manager of that assembly line. And if I don't show up to work, you have to discipline me. We could have been friends. We could have had barbecues. Our families might have known each other. We might have gone to a sporting event together. And then it becomes super awkward. I get it, but that's a big problem of, like, you hear it all the time. Like, it's business, is not personal. It's business, is not personal. People cannot make that distinction, in my opinion. It's very difficult for me to do. And I mean, I manage staff. It's very, very difficult. So that's one thing. And the second thing is, what's that?
Shout out to Ashley.
Yes, absolutely. It's very hard to manage her, because she was a friend of mine and my family's. Her and her husband are family friends of ours. They were before. That's actually a very good example. They were before we hired. She came on as working with me, and now she, works on a very large segment of our business. And when she does something wrong or does something I don't like, and vice versa, we have a hard time talking about it because of that relationship. It is what it is, and we work through it. But a lot of people don't have that ability to work through it, or they just don't care enough to do it, because they know management, upper management, won't discipline them for not doing the management. So we have that there. And the second thing I wanted to ask is, at what point in time do you engage, not necessarily HR, but a third party to come in and help you with problems you're having at the office or at work?
Well, I think, that's very much company dependent. It depends on the size of the company. If you have general counsel, I think that should be general counsel's job to figure that out, because if you're at a point where you need outside help, I think usually that signals that you're having maybe a potential issue with an employee that could be terminated, wrongfully and want to sue afterwards. I think that's a big one. Anything that's really outside of the core HR competency. I mean, I understand different HR people have different skills, but anything that would start bleeding into accounting, I would start looking for outside help. And really just putting the pride aside and understanding as an HR person, when is it time to speak to general counsel or accounting or different management people. Yeah, I think anytime you have a potential for a lawsuit coming at you, that's when you need to talk to somebody else.
Yeah. Well, what about, let's just take a little bit deeper here. What about like a sexual harassment investigation? At what point in time, if there is any, do you need to say, look, our HR department is more than capable of handling this, but for purposes of extreme bipartisanship, but to ensure the fact that this is a completely independent, non-biased investigation, when do you go to a third party?
Well, I think the third party that you would have to go to in a case like that is one of the C-suite of employees, maybe the CEO or general counsel. If general counsel is existent and part of the C-suite, that's when you do it. I think HR needs to let go a little bit and understand that, hey, we are here to advise on this issue, but we can't make the decision for you. And I think the C-suite, like the CEO or manager, higher manager, needs to reach out to general counsel or outside counsel and then tell them, hey, this is your show to run, use HR as need be.
Yeah. And then well, I guess that this is getting into a different topic that I don't want to touch yet in this podcast. But it's a very good one that we'll get to. So moving on from like handling disciplinary issues, and I guess we kind of bled into legal, and I spoke about it last segment. What other parts or tasks that are getting assigned to HR should they not be handling?
I mean, this is kind of related to disciplinary issues, but disciplinary issues I look at as between the company and the employee. So interpersonal issues amongst employees themselves. I think it's very important that HR is not, as we said before, turned into the referee for these types of issues between employees. I think that's something for the manager to handle, because the manager is in charge of these employees, to manage them and understand what their personalities are like and deal with them every day and know the worth of each employee to the company. And I think it hurts a lot of people's feelings to understand that they might have less worth to a company than their fellow employee. I think that becomes very difficult for people to understand that there is a hierarchy within these companies, and what you provide for the company or the value you have to the company really is going to color the disciplinary issues or interpersonal issues and how they're dealt with. I think we talked about a situation with a security guard who comes 5 minutes late every day versus an engineer, and how, you as a manager, you want to deal with the engineer differently than you would a security guard who's coming late because of the nature of their job. And I think HR, if they're very separate from the everyday working environment of the employees that are dealing with interpersonal issues, they shouldn't be the ones dealing with it. I think HR should be there to advise the manager on what the policies and procedures of the company are. If the manager is unclear, again, going back to the handbook and what the handbook says about dealing with these interdisciplinary issues. And just to say that the importance of having this handbook is because if you don't have this scheme to deal with these issues beforehand, and if you haven't thought it through, what's going to happen is the company is going to get accused of acting unfairly, because the first thing that the employee is going to say is, hey, this wasn't in the handbook, or I didn't know about this, or this is just happening now. And that really leads to a lot of problems for companies.
Yeah, and I just want to highlight, because I want to make sure I understood correctly, because I think I agree, which is you have a handbook and you have a policy to not do something. Let's say it's be late. If you don't enforce that policy equally and across the board, there's going to be issues.
Yes.
Okay. And I agree 100%, because at the end of the day, I mean, there was a quote from my wife's grandfather. Had a quote. He was a union foreman for a large corporation, and we talked to him about work once in a while. And he made a comment where he'd deal with people's problems and say, what are you talking about? You did this to yourself. Like, I think it was an issue with him either showing up to work drunk or late or something. It was some crazy example, the employee, where grandpa was like, you did this to yourself. I'm not firing you. I am not refusing to help you, but I've told you 4 times, you have to show up on time. You have to show whatever it was. You have to do X. And then eventually it's like, I can't help you anymore. Right. And so in that person could come back and say, well, I didn't know the policy. It's like, no, you can't, because you were informed 4 times about what the policy was. It's enforced equally amongst everybody. There's no discrimination. There's no retaliation. There's no basis otherwise for you being fired, except for you violated this 4 times. And I think that leads very heavily to having companies actually do what they're supposed to do, specifically HR departments, in drafting the policies and oversight of those policies, not necessarily enforcement.
And again, what makes HR so difficult, and being an employee or an employer so difficult, is that kind of human philosophy comes into it. These issues of what is fair and what is not fair, and what is the goal of the company here? Is it to preserve the company? Is it to make the lives of the employees better? What is happening here really gets very complicated in how to deal with these employees. It really makes HR people feel like they're the bad guy a lot of times, because they have to go fire someone or discipline somebody that they have a close relationship with, and it becomes very difficult for them because of these blurred lines between personal relationships and work relationships, and again, what people think in society is fair and unfair for employers to be able to treat employees. So again, we're coming up on the end of our second segment here. And in the next segment, we're going to discuss our new titled segment that we call "Would You Take the Case?" Where we go over a real life situation that we found on Reddit and discuss it. And I'll tell you at the end, as a plaintiff's attorney, would I sue this company and take that person's case? So stay tuned. And we're back. Welcome back
with the Bobs.
The third and last segment here for today's podcast. We're doing a new segment called "Would You Take the Case?" where Ryan brings me a set of facts as a fictional potential client, and we talk about the case and whether I would take it as a plaintiff's attorney and sue your company.
Yes. And to add a little bit of caveat and disclaimer here, we are California licensed attorneys. We are also, well, I'm licensed in a few other states, but just for everybody out there listening, the caveat is we are making the comments as to our beliefs and understanding as of the date this podcast is recorded, based on California law, sometimes federal, but we'll explain that at the time. And then based on the facts we have. So anybody out there who's listening might think we're wrong. You're probably wrong, and we're giving you our opinions as of today. And I'm sure, depending on whether Arta takes the case or doesn't in this hypothetical, we'll steer you there. So just a quick caveat, quick explanation there.
And none of this shall be construed to constitute legal advice to anybody.
Seek an independent lawyer or consultant before you advise yourself.
Yes.
Not your lawyers. We have no lawyer representation. You're not even calling us, so we don't know your facts. We
don't
can't
have a phone
analyze.
Number. Actually, they do. If they Google us, they could find the phone. Anyway, we're not your lawyer. Screw you.
Yeah.
So, Ryan, if you want to go ahead and introduce the facts as we call it in the biz.
Yeah, what in the biz. One last caveat. These are not real clients of ours. These are on the internet, publicly available. So there's nothing confidential here being disclosed.
Yeah,
okay.
We go on Reddit and look for interesting stuff to talk about for you people.
Yeah, so it's all there. You can Google it. Okay, so I walk into Arta's office as a hypothetical client. Arta, I was terminated from my job because they want me to work overnight shifts randomly all of a sudden, and I don't want to. They're telling me that I'm a nurse, and apparently there was another nurse who worked that shift who just suddenly quit. They need someone to go there and cover that shift immediately. I am pregnant and my first trimester, and I'm really tired. A lot of fatigue.
You look great, though.
Thank you. I work out a lot.
Yes.
At least I think about working out a lot. I have a lot of fatigue. I did not tell anybody at my work that I'm pregnant because I think they fired somebody before who was pregnant. And then I think the company also forged documents to make it look like the person they fired did stuff wrong, so they had a reason to fire her. I emailed my supervisor right after they assigned me this new schedule and told her, my supervisor's female, that I was unhappy with it, and I had to take it, but it was better than quitting out of nowhere. HR then responded to me, but after I emailed my supervisor, and told me, really threatened me, that if I don't work that shift, I'll be terminated immediately. And so I took it. Again, I don't want to be fired. A week later, I was pulled into the office and they fired me. It makes no sense, but they did. I was told I violated a policy. Again, I'm a nurse, so it's a medication policy. And HR didn't give me any more details. What person it affected, what I did wrong, anything. Honestly, it's a lie. I told the HR person that she was lying. And as she was reading my termination letter, she just shushed me and wouldn't let me talk and finish reading the termination. The next day I emailed HR department in general and asked if they're going to report me to my medical boards, and they responded with no. Now, if I really put someone in danger, and I'm required to uphold these ethical standards, they'd have to report me, right? Like they'd have to report me to the boards if I did that. And the fact that they wouldn't or didn't know they had to, I believe means and proves that they're making everything up. Why would they do this?
Okay, well, that is a great fact pattern, I think, for a potential client. I'm going to blow the mystery out of the water and tell you right now, I'm not going to take the case. And we're going to go over why. I think, first of all, let's talk about the things that I want to get rid of very quickly. The issue about the forged documents and the medical board issue. Forged documents, none of that matters. I don't care about any of that as a plaintiff's attorney. That's all potential, okay, if we get into the case and really go into it, but as an initial way of looking at the case, I'm not caring about that because it's a he said, she said. There needs to be a lot of discovery done, yada, yada, yada. That's ancillary. The thing about the board, also ancillary. This is a he said, she said issue. We don't really know because we don't have an official answer from HR or the company on why they're not going to report it to the board. And that is not enough to prove that they're lying at this juncture. Okay, so the big issue that we want to talk about here is the pregnancy discrimination. As you may or may not know, pregnancy is a protected class. So if you are dealing with issues related to your pregnancy and they are making it hard for you to accomplish your job at work, you cannot be fired for those for being pregnant, essentially, if there's a way to reasonably accommodate you. Ryan, do you want to add anything to that?
No, I just want to make a highlight here, which is the Pregnancy Discrimination Act, the federal law, prevents any kind of discrimination on the basis of pregnancy, childbirth, or related medical condition, along with California under the Fair Employment Housing Act, the FEHA, also protects California residents of the same and similar. We just wanted to make sure I highlighted that.
Yes, thank you. And one of here's the most important thing that saves the company in this case and makes me not want to take this case as a pregnancy discrimination case is the fact that there was no notice to the company. If the company does not know that you are pregnant and that you have some work restrictions from your doctor, say, you can't lift more than 10 pounds, or you can't be on your feet longer than X amount of time, for consecutive minutes or something like that, then there's no protection for you because the company has to be reasonably on notice and given an opportunity to address what is making your job difficult to do due to the fact that you're pregnant.
Can I say that? Can I say that a little simpler, which is they can't fire you for being pregnant if they don't know you're pregnant.
Exactly. Yes, that's probably the best way. And being a lawyer, I usually talk too much, and that's a great example. But just in general, the pregnancy discrimination cases for plaintiffs' attorneys are fantastic cases. And why? Because they play well with a jury. If you're in front of a jury of 12 normal people and you have a pregnant woman sitting in the witness box as the plaintiff, this is a very empathetic person for the jury to be able to relate to. They don't like pregnant women being treated badly, and it's very likely that they're going to be making a decision favorable to the plaintiff if it goes to trial. So a lot of these pregnancy discrimination cases settle before going to trial. I mean, almost all cases settle before going to trial, but a pregnancy discrimination case will probably settle with less hassle for the plaintiff's attorney than say just a discrimination case based on other forms of discrimination. So one thing, Ryan, that I want to talk to you about on the defense side is why a company might settle early on, even though the company might feel like they did nothing wrong in a situation where they're being sued for pregnancy discrimination.
Yeah, very good question. I get this question a lot. And that's because I tell clients a lot of times to just pay the ransom, we call it, pay the settlement, whether they believe anything is wrong or not, or they did anything wrong, or they have substantial documentation. And that's on a pure business decision level. For example, if you have $1 billion company or I'm sorry, not $1 billion company, $1 billion company, it's going to be a different decision. You have a small 10, 20 person supermarket, let's say, a little convenience store. This happens, your amount of money that you can dedicate to legal services and defense is going to be much less than $1 billion company, my previous example. So if a pregnancy discrimination case like this came in the door, most likely with better facts, but if it had teeth, I would recommend the client settle for a reasonable amount. Again, sometimes you don't have that option. Sometimes the demand that comes with a fact pattern like this or similar could be $1 million, and obviously that's not something you're going to pay. But sometimes they come in with reasonable settlements. So there's a couple of firms that I've been adverse to that, although I didn't believe in their clients, their settlement numbers were less than my office's retainer amount. So why would you fight it when you have a certain answer? The other side of that coin, and I have clients who take this side I'm about to speak about, which is if we show weakness, you will be sued upon sued upon sued, no matter how much confidentiality is in your settlement agreements, no matter how much you think your people don't talk about it, the word gets out. Absolutely gets out. People will sue you and they know you're going to pay. So we don't want that mantra. And if it costs, and I love this, not only from a business perspective, but as a lawyer, and this is how I get paid, but I love how companies will defend their honor essentially and set a standard of, look, if you're going to sue me, then, and again, in situations where the client, the company client understands and believes it has done nothing wrong. But there are situations where things have gone wrong. Everybody acknowledges it. We come to a settlement, which is much more than would have been paid in a fact like this. But in specific examples, like we just gave here with the nurse, in situations where the company doesn't believe it, the plaintiff's not going to go away with a reasonable number, like very small. The company will fight it, and they'll set a standard of, if you're going to bring these facts to me that are BS, we're going to fight you. I don't care how much it costs me, but we're going to win, and we're going to set that, prove it. And they don't. They usually don't, and they go away, or we win at trial. So it's really a business decision. And again, as much the clients that love to pay the large amounts of money to defend these cases, it's a good strategic for the future. But at the end of the day, your business only makes a certain amount of money. You can't make those ransom payments.
Yeah, and that's a very good point. And the economic factors also weigh in as a plaintiff's attorney, and that's another reason why I wouldn't want to take the case, because in these facts, the issue about going to the board and lying about the medication policy, and issues about forging documents to fire another employee who was pregnant, that takes a lot of money to go through and conduct discovery for a plaintiff's attorney. Most clients are not coming in with $10,000, $20,000, $30,000 that they can put down for a retainer just for costs. I mean, even if I decide that I'm going to do the case on a contingency basis for attorney's fees, I'm not doing it necessarily on a contingency basis every time for discovery costs. If you don't have the strongest case and you still want to pursue it, we can pursue it, but you would have to bear the brunt of these costs and the risks, because a lot of times plaintiffs, when they don't have anything at stake themselves and they're just playing with house money, having the attorney pay for everything, then they're much more willing to lie or not come out with the entire truth. So
yeah, or write it out and use your money, the plaintiff's attorney's firm's money and credit to really write it out and to get something, because they have nothing to lose. You're right.
Exactly. So that's a major issue too. So that's something that again, from a plaintiff's attorney's perspective, I'm giving you this perspective so you understand as an HR person who's listening to this, all the different factors that should go into deciding how to deal with a lawsuit or how to deal with terminating an employee.
Yeah.
And there, because there is no cookie cutter way to deal with any of these situations. Every single situation is unique, and there's a lot on the line here in terms of money. So you have to treat every situation with the respect as a unique situation. And with this, I want to segue into the issue of why a company would essentially, according to the person who was coming in the situation, the facts, lie to fire them. So Ryan, do you want to talk about this situation where a company is not giving possibly the real reason that they're firing somebody during a termination process?
Yeah, I have 3, maybe 4 reasons for that. Remember, to all of you listener, I'm speaking to the one listener we probably have at this moment.
What's up, Matt?
I'm speaking to everybody out there. Remember, we're speaking from like knowledge of the industry. We deal with this every single day. We see these lawsuits every day. Thousands get filed in Los Angeles County alone. There's a lot of it, but you might not see that as an employee of a company. You might not see any of this interaction with, or even from an HR department standpoint, you might not have any of these issues at your company. So you're thinking, wow, well, they have all these laws, like why? No one does this here, right? So just to kind of get into perspective, we see this every day. So the reasons mainly, I would assume, would be to not pay unemployment benefits. In California, there's a differentiation between cause, for cause, and without cause terminations or layoffs, whether or not they're automatically entitled to unemployment benefits. That's one. And that would be debited against the client's state account, and then it's a fight from there. Second would be to cut off other benefits, potentially whether contractual or otherwise. Sometimes higher up employees, if they may have stock options, or they may have other rights or golden parachutes or something like this, that are all cut off based on cause, or if the termination is for cause or without. And then so that's 2 and 3, or just 2. And the last one would be to probably deter a lawsuit. I mean, from an individual's perspective, again, we're speaking of, like, I don't know, I'll give an example. This nurse's perspective from the example we gave earlier. That person might not have a legal knowledge. They might not know any attorneys. They might not have any friends that he or she feels comfortable talking to. And so they're gonna think, because I've seen this personally from both clients of mine and people I've had to defend against. Well, I don't really know if this is a case because they fired me with cause. And so no one's going to believe that it was without cause because it's a company. I'm not going to sue, or not even think about that, because it just deters them immediately. But by seeing those words for cause, or however they phrase it, that they're going to have zero weight in a court of law, or from a jury of their peers to determine whether or not they were wrongfully terminated. Arta, what are your thoughts on that last point? So California, all employees are at-will employees, which means that if you are hired, and again, for all of you, the people out there that are saying, well, there's always exceptions, there are always exceptions. Handbooks can be drafted in such a way to constitute a contract. All that aside, basics, facts here.
That's the default.
Default is an employee is hired, they're at will, unless stated otherwise, which would be like a contract. So that means I can hire Arta right now to work on my assembly line. I can hire him. He can set him to do his job. I can fire him for any reason, and he can quit for any reason. That's held both by the employer and the employee. There's no indentured servitude, provision in California law. Is actually against that, and federal, as we all know. So at-will employees can be fired at any time for any reason. That's not discriminatory.
Or no reason at all. You could just tell them, listen, you're fired.
Yeah, exactly. You're fired for whatever reason. Again, there's always exceptions, as long as it's not discriminatory or otherwise against the law, federal or state. So if you have a contract, though, so if Arta and I have that same example where he's working on my line, but I'm hiring him pursuant to the terms of a contract, then he can be terminated by the terms of the contract. And there's, again, always exceptions, but that termination of that contract might say that he can assign his rights to other people or delegate his duties, which means he can say, Ryan, instead of paying me, pay my mother-in-law. Instead of me doing the job, I'm going to hire, Huckleberry Finn to do it, or whatever, Tom Sawyer to do it for me. Sometimes if you do that without the provision in there, that's a breach, or material or otherwise. So the ways you can get terminated or could be subject to termination, or to quit if you're the employee, may be governed by the terms of a contract. And so it's very important to note, though, in California, default rule, which I say default so lightly because California is so employee friendly, is that you're an at-will employee, which means you can quit at any time for any reason, or you can be terminated at any time for any non-discriminatory reason.
Okay, wonderful. I think that's a great little background on that, and I think that's a question that people really struggle with, and and really segues well into the issue of 2 weeks notice. 2 weeks notice is something that comes up a lot. I get a lot of people calling my office saying, "Hey, I got fired and I didn't get my 2 weeks notice." That's another thing where I usually just say, "I'm sorry, I can't help you." And maybe that's another thing, Ryan, you want to address what is a company's duty regarding 2 weeks notice and giving an employee notice before terminating them?
Yeah, I mean, it's polite. It's a polite thing to do if you're going to terminate someone to say, "Hey, we're going to fire you in 2 weeks," or "You got 2 weeks to get out of here." But then again, you're going to pay someone for 2 weeks, knowing they're not going to be there. Why would they care to do the job? From an employee's perspective or employer's perspective, there's no reason to not let them go. Usually, you let them go and you give them a 2 weeks, a severance or a 2-week payment, so it's like they're working, but they're not. But on the employee side, I find this very interesting. I've heard lots of talk about it. And my personal opinion is that giving 2 weeks notice is like industry standard, right? You can give more, and all that does is, well, there's a lot of different ways to look at this. Optics wise, it makes you a reasonable person, right? It makes you be able to most likely use that employer, unless they walk you out when you give the notice, as a reference in the future. If anybody asks you if you gave notice when you left, you can be honest and say you gave notice, all that good stuff, like for future jobs. It also allows for the employer side, if you're in a good standing with them, the employer can like essentially offboard you and onboard somebody else, or gain your responsibilities over that period of time, so to not lose business kind of traction or involvement. If you're a salesperson and you're the only contact at company X, obviously the company would want someone to come in and understand company X, so the sales can continue to go to that company X while you're gone. Bad example, but you get the point. But I also, so that's kind of my understanding and belief of how it works and why it's there. But my more of an opinion now is, to me, giving 2 weeks notice is like tipping at restaurants. It arose out of a need for an employer to subsidize its own business. Don't jump on me, or jump on me here if I'm wrong, but I think I'm right, which is tipping arose in a time where restaurants couldn't afford to pay their employees hourly rates. So instead of paying them, they encouraged the patrons of the restaurant to tip, which would offset the employer cost of the income to the people or the employees. 2 weeks notice is like that. If I said to you, screw you, I quit, the employer doesn't lose anything because the employee has a right to do that anytime, barring any contract. But what does the employee doesn't lose anything, but the employer does. The employer loses all the traction that employee had, to the extent that there was anything that they couldn't offboard, like we spoke about earlier. So what I believe is employers started giving bad references and talking, essentially bad about that person, saying, well, they just left us high and dry, when, there could be a million different reasons as to why that employee left in the first place. But also the employers set this quote unquote tipping standard, where if you don't give a certain amount of notice before you leave, again, which you're not legally obligated to give in any way, then the employer would give you a bad reference. They talk crap about you. They whatever, make it hard for you to collect benefits, any of these things. So it's a tipping culture where the employer set a standard where it's not followed, the employee loses, even though there's no benefit whatsoever conferred to that employer by law for the employee to follow.
So that's a great explanation, and I think it also highlights the difference between practical solutions and strictly legal ones. Because a lot of times you might have a strictly legal solution, but that legal solution is not economically feasible to pursue as somebody who's been fired, and you can't. So that puts a lot of people as employees in a bad position, and also gives a lot of leverage to employers, because they know a lawyer is not going to take that case. And if there's a government agency that deals with something like that, they're likely to be overburdened and won't be able to get to it. And so that's a risk that a lot of employers will take. Another similar situation, kind of a post-termination situation that comes up a lot, where I'll get a call from people asking what they should do, is um, people who have been fired, and then a company will call them a short time afterwards and tells them, hey, you have to come in and explain how to do X, Y, or Z with
Yeah,
software or something like that.
yeah.
And that if they don't come in to fix the software or deal with whatever problem that the company has that's been caused by the employee's termination, they're going to get sued by the company. Which is kind of a funny thing to think that these companies are out there threatening people after they've fired them. But that's a situation that we run into a lot. And from my perspective, I tell clients usually, you know what, there's no legal liability for you here. You've been fired. You don't owe them anything unless there's a contract that says so. And in my opinion, the best recourse there is just you either ignore the company, or you tell them, hey, listen, I'm happy to help you at my new consulting rate of $250 an hour, and see how the company reacts at that point. Because as a company, you have to be responsible enough to understand who you're firing, why you're firing them, and what the consequences of firing them are going to be for your business outside of legal implications. So,
Mhm.
as we talked about before, this is why you need your managers involved in termination decisions, because you have to know how important this employee is to your business.
That's such a funny thing to say, because you're 100% correct. I've seen Reddits or TikToks or whatever, where there's an exchange, the person who posts their exchange of messages with their supervisor or their boss, and the supervisor or boss always, in this example, in this, like, come back and help us in this little realm here, always tries to put it on the employee as it's their fault. Like, you left me in the lurch. You didn't do this. You didn't do that. It's like, even if all of that's true, like, what are they doing? It's not legal, right? There's no legal obligation, like you said. And all they're doing is playing against that ex-employee's emotions to try to come back and do what that person does not want to do now, which is either establish the connection back with the client, figure out what their job was, find where the files were saved, learn the printer code, whatever it is, right? It's just hilarious because it's always the same thing. It's the same tact. I can't believe you did that. We're a family here. You should have told me. You didn't give 2 weeks notice. Why didn't you write down your stuff? Why didn't you follow protocol? It's like, were you not paying attention the entire time as a business? Like, you have your crap in order. I love that example because it's so funny and it happens so often. But unfortunately, people buy into that because they don't want to be, bad-mouthed or fight with disability, fight with like unemployment benefits, stuff like that. So a lot of times they'll go back and help them to their own detriment without being paid for however long that period of time is. And it's unfortunate.
Yeah, again, it just highlights the big bank takes little bank situation that a lot of people are in when they're dealing with former or current employers in these types of difficult situations. If I didn't know the law, if I was just a regular person who had been fired from a job, I was a software engineer or something like that, and I got a letter from my employer's attorney or ex-employer's attorney telling me they're going to sue me if I don't come and give them an explanation of how certain software works, or these passwords or something like that, yeah, I'm going to be terrified, most likely. And it's going to cause me to have to possibly go consult with an attorney and find an attorney and spend a lot of time. And it might just be easier to cave in and go in and do what they're asking. So again, there's more than just legal considerations that go into a lot of the decision making here, because of the expense of the legal process and the time that it takes to get things resolved.
Yeah, and really to highlight this episode of, like, to sue or not this episode, this segment, to sue or not to sue. A lot of businesses take into account the cost of defense. Some have insurance, some insurance policies cover certain claims. Some attorneys won't even give that analysis because they want to be paid their hourly rate. But 100%, it's always better for the business to bring you back for free, to get them up to speed with a new person, even though you have zero obligation legally to do that.
And again, it's one of those things that just, like I said, highlights this power imbalance that makes employees extremely frustrated at how they're being held captive by their employers a lot of times, because of the inability for people to just go out and find an attorney. Because as an attorney, when I look at a case, I want a case that is just set up from the get-go. I want evidence. I want witnesses. I want an easy case. If I'm a plaintiff's attorney who's doing things on contingency, it only makes sense for me to do easy cases. Because here's a phrase I hate: at the end of the day, when you go to a jury, Ryan, how many people as a defense attorney do you have to convince to win a case?
Was it 4?
Four. How many people
Yeah.
does the plaintiff's attorney have to convince to win a case?
I think it's 9 out of a 12-person jury is 3/4.
So that's a huge advantage to the defense in just odds of being able to win a case, just odds without taking into account the actual process of the trial and the performance, but just on the face of it. So as a plaintiff's attorney, you're really looking at situations where it's almost 100% liability on the company, or it's so clear because the cost of the risk of going to trial is too high. And to lose 2 years of work and all the expenses that go into depositions, that go into mediations, that go into serving people, filing lawsuits, and all the expenses that are associated with a lawsuit make it so that attorneys only want to take the best, most guaranteed victory cases.
Yep, agreed. And the unfortunate thing is that California litigation has been specifically been just inundated with employee side claims brought by plaintiffs' attorneys, hoping to get a quick dollar. But then a lot of them, and I know a lot of them have been against a lot of them, who are very smart, astute people, great attorneys, and they'll fight a company, and then if they win, then law is essentially made. Sometimes it's appealed, sometimes it's upheld, but law is made based on how the cases come out, and certain fact patterns have evolved in a way in California, along with the legislature, to make such a heavy, slanted hill to climb for employers that it's almost becoming unbearable, if it wasn't the second or third largest economy in the world, to run a business.
And that's, I think, something that we should talk about next week, is kind of the effect of California legislation on employment law and how that's affected how employers do business, how defense firms do business, and how employees have literally been on the short end of the stick because of legislation that has been designed to help them. So last thing that I want to go over here is your view on how, in this fact pattern, HR handled the termination here. So again, just to review, in this fact pattern, the employee was brought in, told that they had violated a medication policy by HR. HR refused to give any details of the violation, like when it happened or who was affected or anything like that, what patient, and the accusation was deemed a lie by the employee. Do you have any thoughts, Ryan, on what would have been a better way, if any, to handle the situation as the employer?
So if we're assuming all the facts that we had were true, just for purposes of this discussion, the fact that they needed coverage for that night spot may be legitimate. That should have been explained, which it seems it was, to the nurse, and that could be legitimate. Now, can they force them by changing schedule? Probably. There may be other documents and information we don't know about that might prevent that, but I think that was okay, although not done properly. And it could have been discriminatory. There could have been 50 nurses, and this nurse was the only one who got told to move. We don't know, but I think that's fine in the fact pattern. Not concerned about that. The termination, though, very fishy. A reason should have been provided, and if there was this medication issue, there should have been an investigation where the person, the plaintiff, the nurse, should have been included on. I mean, in any investigation, you're going to take the statement or testimony of the person who's alleged to be have done the offense, unless there's some kind of uncontroverted evidence to show that's not needed. But again, it seems very fishy, given that there was a very vague and ambiguous reason given for termination, no support of it, and no seeming basis for it. That would cause concern for me. It would cause me to do my own little investigation if this client came to me asking, hey, we're going to be sued by this person, this is what we did. So I think the first part of moving the nurse isn't concerning, but how they handle the termination absolutely is.
And one piece of advice that I would give to employers is that the number one reason people want to sue is not the fact they got terminated, but how they got terminated, the process. And this is the perfect example, because by doing it this way, by not being upfront with the reasons, by being evasive, by shushing the employee during their termination, what you're doing is causing a real emotional response to build up in the employee. that they feel they've been treated unfairly, and now they want retribution. They want somebody to make it right, and that's what causes them to go out to seek out a lawyer. If you terminate somebody as a company and you give them reasons like, hey, you screwed up here, here, we have a policy against what you've done, or we have this list of you being late this many times, and have the manager involved, and have the manager explain their reasons, then this person is going to feel like they've been given real reasons for their termination, and that they bear some of this responsibility. And I think if you want to deter lawsuits, that's how you're going to have to behave as a company.
Well, and just kind of add that in the nurse example, if it was actually a medication issue, there's ways to check, depending on kind of medication it was, there's ways to check in a hospital system, right, to see. So if it was, let's say, a morphine that was administered to someone who needed methamphetamine or something, I mean, that's a big difference, but we'll start with an M. Again, terrible example, but you get the idea. There's a way to check that. And if the nurse might not think he or she did anything wrong, but there's ways to prove it. And even talking to that nurse in that situation might have elicited the same, I didn't do anything wrong response, or, oh, I couldn't have given that person methamphetamine for whatever reason. I mean, sometimes you don't need to do that. And that's kind of what I was going at earlier. And I agree. And if you give them that response, though, you give them the chance to speak in an informal environment outside of litigation or lawyers, they sometimes, if not a lot of the times, bear some responsibility, which then again reduces risk for the employer facing a lawsuit.
Yeah, and exactly. And as I always say, the whole point and whole organization of your HR department should be to avoid lawsuits from employees. If you handle your business in a way where you're doing everything you can to check off the list of things you need to do to avoid getting sued, you're probably doing right by the employee by handling things that way. And again, the other lesson is that every single one of these situations is unique, and you need outside help from an expert in the employment field to advise you on these situations, because every single fact, every small fact that you might be ignoring could be something that you don't realize as somebody who's not trained in the legal profession, or even who's not involved in specifically employment law, that could be a big issue that would affect your company. So thank God that's true, because that's what keeps us in business as attorneys, and how complicated everything is. And just remember, just reach out to people as HR people, reach out to attorneys, reach out to general counsel, try to impress upon whoever is in charge of the HR department or at the C-suite level who oversees HR the importance of due diligence, and how a little bit of money spent on legal counsel is going to potentially save you thousands of dollars in legal costs, and hours and hours and hours of headaches, and people getting deposed at the company in a potential lawsuit, which is just going to be bad for everybody.
Yep, agreed. Well said.
So that's it for today. Next week, like I said, we're going to talk a little bit more about the effect of legislation in California regarding employment law, and how that has changed the landscape of employment litigation, and changed the way that companies react to being sued in California here by employees. And the way that defense attorneys, from my perspective as a plaintiff's attorney, have began to change and handle these situations. So again, I'm Arta, Bob number one.
I'm Ryan, Bob number two.
And I hope to have you again joining in our podcast, and tell all your cool HR friends about us.
Yeah, and we'll be coming to a SHRM conference near you.
Yes, and we're going to host a pizza party this time. You guys won't have to do any of the work.
Yes.
Unless you want to. I know you guys are good at it. All right, take care.